Good day. My name is Vincent Palaganas Espirita, BS Criminology 2, Block 3, and today I will discuss the Public Act 7438, or the Act defining certain rights of person arrested, detained, or under custodial investigation, as well as the uh, duties of arresting, detaining, and investigating officer, and providing penalties for violation thereof, be it enacted by the Senate uh, and the House of Representatives of the Philippines in assembled or Congress assembled. Section 1, Statement of Policy. It is the policy of the government to value the dignity of every human being and to guarantee for respect for human rights. Section 2, Arresting or person arrested, detained, or under custodial investigation, as well as the duties of arresting, detaining, and investigating officers. Letter A. Any person arrested, detained, or under custodial investigation shall at all times be assisted by counsel. Letter B. Any public officer or employee or anyone acting under his order or his place who arrests, detains, or investigates a person or any person in violation in the commission of an offense shall be informed the latter in the language known to and understood by him of his rights to remain silent and to have an independent or competent and independent counsel who shall at all times be shall all times be allowed to visit and and confer privately the arrested, detained, or person under custodial investigation. If such person cannot afford the services of his counsel, he must be provided by or with a competent or independent counsel by the investigating officer. Letter C. The custodial investigation shall be reduced in writing, provided that before such report is signed or thumb mark, if the person arrested, detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or by the assisting counsel provided by the investigating officer. Otherwise, such investigation shall be null and void and of no effect whatsoever. Letter D. Any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing. Shall be in writing. Shall be in writing. Shall be in writing. Shall be in writing and signed by such person in the presence of his lawyer. In the absence of, or in the latter's absence, upon a valid waiver, in the presence of any of the parent, his spouse, his older brothers and sisters, um, to the municipal mayor, the municipal judge, the district school supervisor, or priest or religious minister of gospel chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceedings. Section or letter E. Any waiver made by a person arrested, detained, or under custodial investigation under the Article 125 of the Revised Penal Code shall be in writing and signed by such person in the presence of his counsel. Otherwise, such waiver will be null and no effect. Letter F. Any person arrested, detained, or under custodial investigation shall be allowed to visit by or conferring with any person of the immediate family, medical doctor, or religious minister or priest, any member of the family or immediate family, or by his counsel, or by national non-governmental organization duly accredited by Commission on Human Rights, or international non-governmental organization duly accredited by the office of the president. The immediate family of a person or the person's immediate family shall include his spouse, fiancé or fiancée, parent or child, brothers or sister, grandparent or grandchild, uncle or aunt, nephew or niece, and guardian or ward. As it used in the custodial investigation, or in this act, custodial investigation shall include the practice of issuing an invitation to the person who is suspected or investigated and who was suspected to have committed a certain offense, without prejudice of the liability of the inviting officer for any violation of the law. Section 3. Assisting counsel. Assisting counsel is any of the lawyer not directly affected by the case, those charged with conducting preliminary investigation, or except those charged with prosecution of crimes. The assisting counsel other than the government lawyers shall be entitled to the following fees. The amount of 150 pesos if the person suspected is chargeable with light felonies. The amount of 250 pesos if the person arrested is liable or chargeable with less grave felonies or grave felonies, and the amount of 350 pesos if the person arrested or suspected is chargeable with a capital offense. The fee for the assisting counsel shall be paid by the city or municipality where the custodial investigation is conducted, provided that if the municipality of city cannot pay such fee, the province comprising such municipality or city shall pay the fee. That municipal city or city treasurer that must certify that no funds are available to pay the fees of assisting council. In the absence of the lawyer, no custodial investigation shall be conducted, and the suspected person can only be detained by the investigating officer in accordance with the provisions of Article 125 of the Revised Penal Code. Penalty Clause or Section 4 Penalty Clause. Letter A. Any arresting public officer or employee or any investigating officer who fails to inform the person arrested, detained, or under custodial investigation of his rights to remain silent and to have a competent and independent counsel, preferably of his own choice, shall fine 6,000 pesos and penalties of 8 to 10 years of prison, or both. The penalty of perpetual absolute disqualification shall also be imposed upon the investigating officer has been previously convicted of a similar offense. The same penalties shall be imposed upon a public officer or employee being upon or under his order or space who arrest or he fails to provide competent and independent counsel to a person arrested, detained, or under custodial investigation for the commission of an offense if latter cannot afford the services of his counsel. Any person who obstructs, prevents, or prohibits any lawyer, any member of the immediate family of a person, a medical doctor, or priest, religious minister chosen by him, or visiting and conferring with privately with him, or from examining and treating him, or from ministering the needs of his soul at any hour of the day, in urgent cases of the night, shall the penalty of imprisonment of not less than 4 years and not more than 6 years, and a fine of 4,000 pesos. The provision of the above section that notwithstanding the security officer with custodial responsibility over a prisoner may undertake such reasonable measures, or prisoner may undertake reasonable measures be necessary to secure his safety and prevent his escape. Section 5. Repairing costs. Public Act number 857 amended is hereby repealed. Other law, decrees or law, presidential decrees, executive orders with the provisions thereof inconsistent with provisions repealed and modified accordingly. Section 6 effectively. This act shall take effect 15 days after its publication of the Official Gazette of the Philippines newspaper and circulated throughout the Philippines. That's all. Thank you for watching, sir. Goodbye.